Hi Barry. After studying your case deeply, what I have found is when you guys entered into a contract, it's clearly passed with all the needs and assumptions of a contract, which starts with an agreement between you and Angelo with an offer and acceptance. Basically, when you sign any contract, it automatically creates a legal relationship where there is certain consideration and there shouldn't be any fraudulence act and misrepresentation. Likewise, none have power to decide about the illegalities. Although the contract started as an oral contract with the telephone communication with support of offer and acceptance, you purchased Angelo's business, where you came to know the monthly turnover was lower than mentioned in the contract, and also there was competitor available. There is also problem with the delivery van and the loader. And in this case, Perry, it is clear that you were misrepresented, and in the advertisement it's clearly stated that there is no competitor, but there is no competitor, but there was actually a grocery shop nearby. Likewise, the monthly turnover was not wasn't 20,000, rather it was 13,000 only, which provides a fake information. In regard to Section 18 of Australian Consumer Law, when there is an misleading and deceptive conduct, it states that the conduct which is deceptive of member of the public in their capacity as a consumer goods and service. So the contract gets void as there is fraudulent representation by the contradictory party. Even after knowing there is misleading representation, if you want to stay in the contract period, then you have right to breach the contract. During the purchase of a business, you have paid the negotiated amount, which includes the delivery van and loader. He came to know through the after you came to know through the finance company, the delivery van is actually leased. The contract was descriptive, and with the Section 18 Sale of Good Act, it got breached. The Section 15 of Sale of Good implies that seller must give title to goods and to buy good to buyer, and it should be free from encumbrances. Likewise, the Section 51 to 53 of Australian Consumer Law states that the seller has right to dispose of good and it must be free from any security, and buyer must have undisturbed possession of good. It is also found that the loader is out of work, which supports the breach of contract, as Section 54 of the Australian Consumer Law has said goods should have acceptable quality, whereas the Section 55 of Australian Consumer Law Sale of Good Act implies that when there is sale of goods by sample or description, there is a condition that good must match with sample and description. There is an obligation to the defendant to either replace or repair the good or pay as per the cost of replacement as repair of the good to prosecutor. Hence, if found any defect or condition of the good is not goods is not in good then condition, then there should be compensation followed by breach of contract. In regard to the Section 15 of Sale of Good and Section 51 to 56 of Australian Consumer Law, Angelo is bound by legal force to compensate the damage. If damage cannot be recovered, then he can obtain an injunction order. Likewise, further, the case can be taken to the court where judgment can be done in the verdict. Thank you.